OUTA today brought an urgent application against government over its declaration of a state of disaster over the electricity crisis. President Cyril Ramaphosa made the announcement at the State of the Nation address last week with immediate effect. Since then, there's been fierce criticism, with legal action also being taken by trade union Solidarity. Let's find out why OUTA is going this route. And joining us is OUTA Accountability Division Executive Director, Advocate Stefanie Fick. Stefanie, good evening. Welcome to the program. You're bringing this action against the president and several others. Just quickly walk us through the names and the entities that you are targeting this to and why.
So there's 8 respondents. I think the most important respondents, the ones that we want reaction from, if I can call it that, is the president, the head of the National Disaster Management, the Minister of Cooperative Governance and Traditional Affairs, because she's the one that declared the national state of disaster, and the National Disaster Management classified the crisis as a disaster. Some of the parties that, and also the Minister of Public Enterprises, we also cited Eskom, for example, because we believe they do have an interest, but we don't ask anything from them because they were not really party to classifying and declaring this a state of disaster. What the case boils down to, it's 2 parts. The first part is just that urgent request interdict to say that while we deal with Part B, which is the review application, please can the court stop the government from filing any regulations, etc. Part B is the review application, and we are, in other words, saying that decisions, the classification of the disaster and the declaring it a state of disaster needs to be reviewed by a court of law, because we believe that that is irrational, arbitrarily taken, and unlawful.
Yeah.
In other words, either relevant facts were not taken into account or irrelevant facts were taken into account.
Well, let's get to the heart of that then. You set out a number of reasons for why you're going this route. There are at least 9 main categories in your legal papers. Just highlight a few of the biggest.
It's, declaring a state of disaster for a situation that's been coming 15 years. You can't use a state of disaster in order to fix your inability to govern, to make sure that there's no electricity crisis. But then people will say, you know what, this is a crisis. How are we going to resolve this? Now, a state of disaster is not the route. Eskom, just 2 days before the president said, there's going to be a state of disaster. In fact, it was declared. They presented their plan to Parliament. Eskom is of the view that, the rolling blackouts is necessary in order not to create a total grid collapse. So the chances of that happening is very slim. They have a plan. It is short, medium, long term. Whether we have a state of disaster or not, we're not going to fix the energy crisis tomorrow. And you know what? They didn't even know about the state of disaster. Eskom, who is, gives South Africa 90% of the energy. So that makes you realize that something is amiss here. The Disaster Act wasn't meant to be used in this way. And if you talk about a coordinated way of dealing with this crisis, you can do that in any case.
Yeah.
The regulations, the legislation out there gives you the ability to fix this without declaring a national state of disaster.
Well, we'll circle back to this Disaster Management Act itself and see whether there's scope for the Act itself to be changed through the course of your action and action being brought by others. But one of the key concerns you highlight, which I suppose will resonate for many South Africans, is that you're worried it would open the floodgates to looting of the magnitude we saw during COVID and the PPE contracts. How so?
You can only assess your current situation by taking information like history into account. And unfortunately, there's a trust deficit. And we saw that even with this, live auditing from the Attorney General and the subsequent reports that came out of the Attorney General's office, is just hair-raising. I mean, still, I get so angry to think that people took advantage of a period in our in our history in South Africa to just loot. And how are we going to stop it now with this state of disaster? Saying that the AG will keep an eye did not help the previous on the previous occasion. So unfortunately, I mean, action speaks louder than words. And in this instance, unfortunately, we have to take into account that this state of disaster will again open the floodgates for corruption.
It would cause a disaster and not avert it, is your refrain and the refrain from other critics. What are some of the other risks, Stefanie, you believe are inherent from OUTA's perspective in going this route?
The fact that, what you're going to, on a practical level, is what is needed is implementation. The political will to fix this problem, to make it possible with current legislation, to give Eskom the support they need in order to take the plan and carry out the plan successfully. One of the first things that they say that is that will help is giving resources for diesel that will really alleviate the problem we are currently sitting with. But other problems, for example, car power, we are also, taking NERSA on review for granting distribution licenses to car powership, because we believe that they did not take into account the absolute economic disaster that is going to cause for South Africa. And we've heard the minister previously saying, maybe not 20 years, maybe we should do it 10 years. And, people thinking that, let's forget about the environmental authorizations because we need the energy now. And I think there is a misrepresentation of what car powership can do. I mean, it's but one stage of load shedding, and it's not going to be tomorrow. If they come to our harbors, you're not going to have the less one stage electricity stuff tomorrow.
Yeah.
Just the way that deal was put together is just not in the best interest of South Africa. So we're scared, with what we've seen previously and what is in the public space, that they will use this opportunity to push something through, which is not in the best interest of South Africa.
Very quick one in closing, Stefanie, what do you think your prospects for success are? I know you've only lodged this urgent interdict today, but have you heard anything from any of those respondents yet?
No, unfortunately, we can't expect them to say anything right now, but hopefully they will. What we expect, objectively what we expect is, we believe in our case, otherwise we wouldn't have done this. We believe that this is in the best interest of South Africa because we need a solution for our energy crisis, of course. We also need free basic electricity for people that do not have electricity.
Right.
That's just a side point. But we need a solution, and we need implementation. But, they have a right to disagree, and let's go to court and do this. We have said urgently, hold back any regulations, and the review application can take as long as, the respondents drag this out and or make it quicker. So we can, if everybody plays together, we can actually have an answer fairly quickly. So we're looking forward to the fight because we believe it's in the best interest of South Africa.